The third party can release to the consent of information. So that is one thing that's really important. While you're engaging with these third parties, quite often they'll take a look and they'll go, you know what, there's no harm here in releasing the information, or I just don't want you to release the unit factor for these reasons, and here's how it would be harmful. But I find quite often they're more than happy and very reasonable to just consent to the release of their information and appreciate being consulted as part of that process. With regards to personal information, so I talked about it being an unreasonable invasion of privacy. If there's information regarding medical that you have in any sort of records, that should be withheld. Information that's identifiable as part of a law enforcement record, that's also determined to be an unreasonable invasion of privacy. A person's eligibility for income assistance or social service benefits is protected under FOIP. Employment or educational history, again, information that's collected on a tax return or gathered for the purposes of collecting a tax. Bank and credit card information, personal recommendations or evaluations. So those are actually your own information. So people's recommendations and evaluations of you actually belong to you. They don't belong to the person that made them, they belong to you. They're your information. And again, as I mentioned, when your name appears with other personal information, such as your race or religious beliefs or your address, any of that, that's considered to be an unreasonable invasion of privacy and it shouldn't be released. The Act does provide circumstances, though, where this exception can be overridden. And so, as I mentioned, it can be overridden through consent. If a person's health or safety is in jeopardy and notice has been provided to the third party, if legislation authorizes it, and so on. So it's not just sort of a one-size-fits-all. You really have to look at what is happening, what is the situation when you're applying these exceptions. So, in terms of discretionary exceptions, this is the one that I would say I would caution around using them too much. Use them if there really is going to be harm. So for individual or public safety, if there's a threat about anyone's safety or their mental or physical health, a public body can release that information. If an individual is going to interfere with public safety, of course they can release that information. These things follow logically. Refuse to disclose you information about the identity of an individual who has provided information to the public body in confidence about a threat to an individual's safety. So let's say somebody goes to your local police department and shares information with them leading to whether it's some sort of a law enforcement investigation. You wouldn't want somebody to be able to go back and actually locate the personal information of that person and find them and go back to their house or all these sorts of things, right? So you'd want to protect that. In terms of confidential evaluations, so determining applicants' suitability, eligibility, or qualifications for employment, or for the awarding of contracts or other benefits by a public body when the information is provided explicitly in confidence. So typically when you hire somebody, they're giving you that information in confidence. They're assuming that you're not going to take that information and release it and post it on your website or do anything like that, right? If that was the thought, they'd never give you any of that information. Also formal employee evaluations. So again, same thing. If you're going through formal employee evaluations with your staff, you don't typically release that information. The other one is law enforcement matters, which is pretty clear. You don't want to be releasing information that may prejudice an ongoing investigation or anything of that nature, so that information is protected. With regards to intergovernmental relations, so this one is if you, let's say you're negotiating with the government of Alberta, or you're negotiating with, maybe the province is negotiating with the federal government, or all sorts of things. This exception allows for conversations that may harm that relationship to be dealt with in camera or to be withheld from releasing to the public. The other thing I'm going to talk about is all of these exceptions I'm going through are also the exceptions that apply to the holding of in-camera meetings. So you need to be using these when you're citing, when counsel's going in camera. You need to make sure that it is citing a specific section of FOIP, the MGA, preferably both, when you're going into in-camera. the next one is local public body confidences. So a draft resolution, bylaw, or other legal instrument may be protected, and typically I would encourage it to be protected. If it's not something that's been finalized, for instance, an agreement, maybe it's something that contains your negotiations that you have with another an individual, perhaps another municipality, anything like that, that would prejudice the town if they release that information. But things such as just having general deliberations and getting advice from your officials, things that are not going to be harmful, they may be uncomfortable, but they should be done in public. Unless it's going to be harmful, it should be done in public. I have heard and I have seen councils who have gone in camera because it's uncomfortable to talk about things publicly. The Act doesn't provide for that. It may be difficult conversations, but they need to be done publicly, just so that the perception is there of open and transparent government. Deliberations, so this is talking about that elected officials part. If legislation authorized the holding of meeting in the absence of the public, so the MGA provides for it, FOIP provides for it, the FOIP regulations, that allows you to withhold that information. So your in-camera packages, I cannot go and contact the FOIP or the town and say release that information. However, if a decision about or any of that discussion about what has happened in camera has been talked about as the public portion of the meeting, that exception no longer applies. So just things to keep in mind. So with regards to advice, proposals, recommendations, analysis, policy options developed by or for a public body. Yeah, absolutely. Correct. Absolutely. You cannot make decisions in camera. You have to do those publicly. But what I'm saying is that once you make that decision, some of the information that you've discussed in camera may no longer be protected, right? So let's say that you authorize your CAO and maybe your mayor to sign some sort of an agreement with a third party. Once you've actually passed that resolution, that agreement's now public. Right? So it's that kind of thing. So it really applies to sort of what are you talking about? What have you authorized? It's real. A lot of this is very much on a case-by-case basis. Like I said, it's not one size fits all. But so going back to advice, proposals, and recommendations by or for public bodies, unless it's going to be harmful, like policy discussions really should happen publicly. It is in the public's best interest, it's in your best interest to do these things publicly and have it be open and transparent. Things that involve personnel, obviously you're going to want to do in camera, things of that nature, but in terms of just general conversation, the bulk of that should happen at a public meeting, because that wouldn't be necessarily protected under the Act. Consultations or deliberations involving offices or employees of the public body. So again, like when your staff come forward and make presentations to council, they should be done primarily in your public meeting. If there is, again, but if it's negotiations and stuff, then you're going to go in camera and you're going to do that presentation in camera. But it's a balance, right? You don't want to be doing too much in camera that could be done publicly, and vice versa. You don't want to be discussing personnel issues in the public. That's not in your personnel's interests and certainly not in yours. Positions, plans, procedures, criteria, or instructions that will be related to contracts or negotiations, those should certainly be done in camera. So when you're talking about contract negotiations, you certainly don't want to be doing that out in the public and then kind of showing your cards, if you will. So definitely you want to do that sort of thing in camera, or you want to, and then for the public body to withhold that information until that contract or whatever it is has actually been finalized and is a public document. Plans, again, related to the management of personnel. So if you're going to be making decisions around personnel and that sort of thing, again, you'll want to do that in camera, particularly before it's been implemented. Plans, policies, projects of the public body, which could reasonably expect to disclose a pending policy or budgetary decision, may be done in camera. This one, again, I would just caution you that, you know, if it's about personnel and things, that's probably fine. If it's about true policy decisions that are outward facing about the community, it may not be a bad idea to do that publicly. So just kind of keep these things in mind about when you're using these exceptions. Incomplete audit reports. So when you get your audit reports, you may not necessarily, until they're finalized, you may want to have a first glance at them, and that's okay to do that at an in-camera session. That's perfectly fine. But when you're ready to actually finalize them, obviously you want to have a presentation to the public and share that information. But these are, so the two are very, as you can see, tied together. So in camera is very linked to access for information. What council can do in camera is also the information that's protected from residents and people from accessing. So with regards to economic interests of the public body, if the public body has things such as trade secrets, financial, commercial, scientific, technical, or other information which the public body has a proprietary interest in that is likely to have monetary value, then you can withhold that information. Given that the bulk of what municipalities and public bodies do is for the good of the public, not generally, you don't make a lot of money in this sort of thing, right? So this is not one that I've seen typically applied, but if you do have something of that nature, you would want to withhold it. Information that would result in financial loss or prejudice of a competitive position or interfere with contract negotiation. So you can see that a lot of these blur over lines. So particularly around that contract negotiation piece. If you're doing that or you're withholding that information, my recommendation would be apply all of the exceptions. Don't apply just the one. You're better served if you can show that there's a few areas of the Act that actually allow you to withhold that information. It also allows residents to understand why. So if I open the FOIP Act and I see, okay, it's this section and this section, okay, I'm more likely to understand that, yeah, they really can't give me that information, and here's why. Research that's done by an employee that could potentially deprive the employee of a proprietary right to publish that information is also something that public bodies have to withhold.